Good afternoon. We're here for the continuation of the November 14th docket of the Court of Criminal Appeals here in Nashville. My name is Robert Montgomery. I'm presiding today. I'm from Sullivan County. To my left is Judge Tom Greenholtz from Hamilton County, and to my right is Judge Tim Easter from Williamson County. And welcome you all here today. It's my understanding there's some students here from Fisk. Welcome. We're glad you're here. Thank you. I'm glad you could join us today. Madam Clerk, are there any preliminary matters?
Yes, Your Honor. There is the matter of order to show cause in State of Tennessee versus Samuel DeMarcus statement in regard to Attorney Edward Kendall White.
All right, Mr. White, go ahead and remain seated. It's all right. I'm going to call your case up after we have some oral argument.
Yes, Your Honor.
So it'll be a while, but I appreciate your patience for that.
Thank you, Your Honor.
Thank you. All right, if you'll go ahead then, Madam Clerk, and call the first case.
Douglas Edward Christian versus State of Tennessee.
Good afternoon, Your Honors.
Good afternoon.
Good afternoon.
May it please the court, my name is Chris Davis. I'm coming today from the Chattanooga Bar, actually, on behalf of the appellant, Douglas Christian. I have to say it's my first time having the pleasure of arguing in front of a Court of Appeals panel.
Let me interrupt you real quick, and I apologize. I should have said this at the beginning. Of course, each side has 20 minutes.
Yes, sir.
And you, as the appellant, if you wish to reserve any time for rebuttal, go ahead and let us know on the front end so we can mark the time.
Yes, Your Honor. With that being said, I would like to reserve 5 minutes for rebuttal, if I may.
Certainly.
Right. Your Honors, the issue that I would like to use my time today to address, which is the principal issue in our brief, has to do with what we believe to be the deficient performance of Mr. Christian's trial counsel, which resulted in the 4 possession with intent convictions that Mr. Christian has, that are the basis for the 20-year sentence he is currently serving. I know the court has likely reviewed the briefs, but if I may, a short version of the facts of the case and procedural history. This has been a far-reaching case over a few years. Want to keep everything streamlined. Mr. Christian was arrested by officers of the Manchester Police Department on November 3rd, 2014 at the Ambassador Inn in Manchester, Tennessee. We know that it was alleged that Mr. Christian had been involved in illegal drug activity, and police became involved in this matter because of those accusations. And as such, when an investigator of the Manchester PD received intel that Mr. Christian was staying at the Ambassador Inn, police arrived at the motel and searched Mr. Christian's vehicle and room. In this search, a small amount of cocaine was found in a pill bottle in Mr. Christian's vehicle, but no other drug or paraphernalia were found on the scene at this time. Mr. Christian was arrested and placed into custody immediately. And 2 days after this arrest, a motel employee called police to tell them that there had been drugs found in the commode of the room where Mr. Christian was staying, and they were attributing those drugs to being Mr. Christian's. Now, Mr. Christian was held in custody for 3 years with various motions going back and forth, but he was eventually tried in October of 2017. As a result of this trial, Mr. Christian was convicted of a Class B felony, possession for 0.5 grams or more of methamphetamine, a Class B felony for possession of 0.5 grams or more of cocaine, a Class D felony for possession of a Schedule III controlled substance, buprenorphine, as well as a Class A misdemeanor possession of marijuana. And the trial court sentenced Mr. Christian as a range 2 offender and imposed an effective 20-year sentence. On direct appeal to this court in 2019, after a motion for a new trial was denied by trial court, Mr. Christian challenged his convictions and sentencing on various grounds, the primary of which was that the trial court had erroneously used foreign judgments to sentence him as a range 2 offender. In an opinion filed by this court in August of 2019, this court affirmed that Mr. Christian's convictions and sentences were as they should be, and the trial court had indeed properly determined that Mr. Christian had the requisite number of qualifying felony convictions to be sentenced as a range 2 multiple offender. Mr. Christian filed a timely petition for rehearing on this matter with this court. As of September 2019, this court denied said petition, and the next step Mr. Christian took was to file a pro se petition for post-conviction relief. And after the amended petition was submitted and filed, once Mr. Christian was appointed counsel, allegations of ineffective assistance of counsel came to fruition.
So
After-
counsel, help me with,
Yes,
you
Your Honor.
raised, I think, 2 issues of ineffective assistance of counsel.
Yes, Your Honor.
The second issue is that counsel is alleged to have rendered deficient performance because counsel didn't object to convictions that were from 1987, used to enhance the range from range 1 to a range 2 multiple offender.
Yes, Your Honor.
What do you contend the objection should have been?
I'm so sorry, can you
What do you
repeat that?
contend that the objection should have been? So, for example, in the brief, I don't see an analysis of why there would have been a meritorious objection. It looks to me that under 4035-106B, the definition of prior convictions is any prior conviction. And when you look at the Sentencing Commission comments, it says expressly that the court should consider all convictions occurring within the lifetime of the defendant. So if the definition of prior convictions is all previous convictions, no matter when they occurred, even if they occurred before 1989, what objection should counsel have raised, the failure of which would have given rise to deficient performance?
Yes, Your Honor. We would submit to this court, and of course, I'm not here to argue today the meritorious or non-meritorious nature of this argument, but we would submit to this court that trial counsel failed to make a timely objection to the introduction of this specific 1987 conviction on the basis of pursuant to Tennessee Code Annotated Section 4035-118. This, where in 4035-118 there was a classification of different felony convictions that post 1989 may be switched to a different classification, and this possession for conspiracy for possession of cocaine was not listed in that. And in 4035-119, it is stated that if it's not classified explicitly in 118, it is to be considered a Class E felony. So we submit to this court that trial counsel should have at least attempted to make an argument that this should be considered a Class E felony as opposed to a Class D felony, as the state used it to range Mr. Christian up to a range 2 offender.
Okay. Thank you very much. Thank you.
Was that issue raised on appeal to the appellate court? Did they take a look at that? I mean, was it, did they look at that issue?
Of whether it was a Class E felony?
Right.
No, Your Honor, they did not take that up on direct appeal with this court.
Okay, all right, thank you.
Why wasn't it raised? Is the issue then waived because it could have been raised in the original appeal?
That is a very good question, Your Honor. We did not have anything to do with the direct appeal.
Sure, yeah.
So I'm not sure why it was not raised then. I know, obviously, this court, that was the reasoning this case was brought to this court in 2019, so I'm not quite sure why it wasn't raised at that time.
Certainly. Typically in the post-conviction context, an issue would be waived if the issue could have been raised to the appellate court on direct appeal and for whatever reason wasn't done so. Typically then that issue is waived in the post-conviction context. How is this issue then not waived if it could have been raised earlier?
That is a very good question, Your Honor, that
That's fair enough. Okay. That's fair.
I have not prepared to answer today.
That's okay. That's okay.
Also, if I may, I am having a little trouble hearing you. Could you move your mic
Yes,
just a little
indeed.
bit?
Yes,
Thank you
thank
so
you. No,
much.
thank you. I
I'm so
appreciate-
sorry.
I appreciate your patience.
Yeah. Any further questions before I continue?
What was the classification of the offense that he was convicted of?
At what time?
The underlying offense, the drug conviction that he got 20 years for, what was the classification of that offense? Well, what was he convicted of initially?
Initially at the trial, he had 4 different counts that he was convicted of. The Class B felony possession for the methamphetamine, the Class B felony possession for the cocaine, Class D felony possession for buprenorphine, and a Class A misdemeanor for
Okay.
marijuana.
So let's assume that your argument is correct and it was a Class E felony as opposed, the prior should have been classified as an E. Wouldn't that still make him a range 2?
No, Your Honor, we do not believe it would. And that's why we assert to this court today that trial counsel should have brought that issue to light at the initial sentencing hearing or in the initial trial. They should have taken this up because that could have altered the way that the sentencing range occurred in the sentencing hearing, in our opinion.
Are you arguing that he should have been sentenced within range one, that that's the ineffective assistance of counsel, was that he allowed him to be sentenced as 2 instead of 1?
We're arguing that if trial counsel had advanced this argument, he would have been sentenced as range 1 instead of range 2, and subject to, obviously, different sentencing parameters and whatnot.
Okay.
Any further questions before I continue? I don't want to cut any of y'all off.
Is this the argument that's set out in the brief?
We did address it in the brief. I do agree with the state that it was possibly not as fleshed out as it should have been, but it was addressed in the brief.
I didn't see citation, and you'll forgive me, I don't know that I saw citations in the brief to 4035, 118, and 119, for example, in trying to develop the argument. Did I miss them? I might have.
No, Your Honor, they are in the record. Actually, that was what Counselor Chad Moore asserted in the post-conviction proceeding itself. But I do not believe they were in my brief in chief for this
All right.
today.
Very good, thank you.
Of course. Please forgive me, you've got me all out of order.
Not at all.
Okay, so briefly, as we discussed, I would like to discuss today how it is our position that Mr. Bud Sharp, who was that lead counsel on Mr. Christian's trial, in his initial trial, and at his sentencing, was deficient in his performance in ways such as failing to raise arguments we feel had validity and could have resulted in Mr. Christian being ranged down to a range 1 offender as opposed to a range 2 multiple offender. And I will speak primarily regarding that 1987 conviction today, but I do intend to also discuss counselor's failure, in our opinion, to reasonably object to certain objectionable statements and introduction of evidence that we feel resulted in prejudice to Mr. Christian. But if I do not make it to that today for any time reasons, please, I intend to just stand on my brief in that regard. As we've already talked about, we feel it was proper for trial counsel to have at least attempted to advance an argument for the differing classification of that 1987 conviction based in TCA 40-35-118. And as I'm sure the court is aware, a range 1 offender is only subject to a period of 8 to 12 years of sentencing, and they also have a possibility of alternative sentences, such as probation or split confinement available to them, whereas a range 2 offender is considered higher risk to society and given a minimum sentence of 12 years with a maximum of 20 years, as Mr. Christian is serving, and can only be sentenced to incarceration with no possibility of that alternative sentencing. So that's what we would argue today is the prejudice that Mr. Christian suffered. He was subjected to an extra effective 8 years of sentencing that he would not have been subjected to if he had been.
I'm sorry, I don't mean to interrupt. With respect to the first argument that I want to make sure we have the opportunity to ask you about, what specifically are the hearsay statements that you believe should have been objected to?
So as we talked about, it was talked about in our brief, but mainly it was fleshed out in the post-conviction relief hearings. There were certain statements brought in on the direct exam by the investigator, from being chiefly the call from the maintenance staff from the motel to the investigator detailing the discovery of these drugs in the commode.
So the hearsay statements from the hotel maintenance about what they found in the toilet when they went to go, I guess, essentially service a call.
Yes, Your Honor.
All right. I believe, but you'll help me, that in the trial record, the state introduced phone calls from the defendant that he had placed from jail, admitting that he essentially had flushed the drugs also. If that's the case, where is the prejudice in a post-conviction context arising from that? In other words, it looks like the exact same evidence came in consistent with the rules of evidence. And so how would have keeping out the hearsay from the maintenance workers then affected the outcome of the trial?
Yes, Your Honor. We feel that trial counsel was, as the post-conviction court noted, employing some sort of strategy to deny ownership of the drugs, but not deny the presence of the drugs themselves. And he focused solely on that issue as opposed to focusing on criticizing and critiquing the sufficiency of the evidence that was presented by the state. And as such, we feel that trial counsel failed to make any significant attempt to protect Mr. Christian from these, what we feel are procedural and evidentiary mistakes. And that in and of itself is what deems his performance insufficient.
But if you have a situation where the exact same piece of evidence is offered, one for an inadmissible purpose, one for an admissible purpose, and the evidence comes in at trial, and the jury considers the evidence properly as part of the universe of evidence in the guilt or innocence determination, and so it's there, how is admitting the evidence under the hearsay objection in this case then prejudicial? Because the jury got to consider the evidence lawfully anyway. And so how does the failure to make a hearsay objection affect the outcome of the trial?
Yes. We feel that there's a reasonable probability that objecting to these statements coming in or this evidence being introduced, that there was a possibility that this evidence could be excluded, or that, I'm sorry, I'm running into my rebuttal time. I do
No,
apologize.
that's okay, but it wouldn't have though, right? It wouldn't have been excluded from the jury. And we know that because the evidence came in through the defendant's own statements, which would have been perfectly admissible. So if the evidence is there, then how could a failure to object have changed the outcome of the trial?
We feel that this just prejudiced Mr. Christian because were these objections made, it would have potentially given a more holistic view of the presence of the drugs, the ownership of the drugs, the possession of the drugs, and how they were found, which had potentiality to weaken the state's case, which is obviously how Mr. Christian would have been convicted if they had a strong case, and they on all 4 counts. So we feel that's how he was prejudiced by this failure on trial counsel's part.
Thank you.
Any other questions? All right, thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. Abigail Renard for the state. This court should affirm the denial of post-conviction relief because the petitioner has failed to establish that he received ineffective assistance of counsel. First, the petitioner has waived his arguments about sentencing range, and in any event, he cannot establish ineffective assistance of counsel, and this court has already addressed the issue. Second, trial counsel made a strategic decision not to object to the detective's testimony because it was consistent with his own version of events. So first, turning to the failure to object at sentencing. This argument has been waived, and to the extent that counsel has made any new arguments about the objection, those were not included in the brief, and those are certainly waived at this point. But regardless...
They would be waived substantively though, right? Because they were not raised on the direct appeal?
Correct. So this court actually did address the sentencing issue fairly thoroughly on the direct appeal. And even though, so trial counsel never objected, and this court, when it was deciding the direct appeal, went through the sentencing fairly thoroughly and concluded that the judgment supported the state's assertion that it was a Class D felony, this federal conviction. And I believe there's a footnote in it where the court goes through the classifications. And then on the petition for rehearing, when this court denied the petition, it noted also that the defendant had waived the issue by failing to object and agreeing that it was a qualifying felony. And then discussed, I believe the defendant had raised the argument about it being a Class E felony potentially on the petition to rehear, and the court said that they disagreed with that, but in any event, it's not really necessary to reach the merits of that issue.
If it were properly classified as a Class E felony, would you agree that he would have been a Range 1 offender?
I am not
Because it was a
clear.
Class B felony conviction, and to get to Range 2, it can only be 2 underneath, right?
Correct.
So if
So
it were a Class E, would you still have?
I think that there's a possibility the state may have relied on different convictions. It's not entirely clear from the record on appeal currently, but the defendant, in this court's opinion, it goes through the sentencing hearing, and the defendant had a range of convictions spanning, I think, 40 years. So there were other convictions going on as well, so I don't know that it would have actually impacted. But again, this court went through that analysis already and determined that the judgment on its face supported that, and to the extent that the petitioner is trying to raise any new arguments now, those are certainly waived.
So were there 2 other felony convictions already qualifying?
There was the
qualifying felony.
1977 one,
Mhm.
and then the record is not clear about the specifics. I believe in his petition, the petitioner attached a notice of seeking enhancement, and that included a whole slew of convictions that the state had provided notice of, but it doesn't include the judgments of those, so I'm not entirely sure based on the record what the details of those convictions were.
Thank you very much, thank you.
Yeah, absolutely. But again, to the extent that the petitioner has not established any reason to object to this, so he also cannot establish prejudice here because this court has already addressed it, and a meritless objection wouldn't have gotten him anywhere. And then turning to the trial counsel's failure to object to the detective's trial testimony, here the post-conviction court properly concluded that it was a strategic decision not to object. As Your Honor pointed out, this evidence would have come in anyway. The defendant had multiple jail calls and text messages where he discussed specifics about the drugs and admitted to flushing the drugs. He testified in his own testimony that he had flushed the drugs and was trying to claim that they were someone else's. And the defense also stipulated that the drugs were drugs and to the amounts at trial. So any objection here, even assuming that there were hearsay statements to object to, would have certainly had no impact on the trial or the outcome of the trial. And if this court has no further questions, we would ask that you affirm denial of post-conviction relief. Thank you, Your Honors.
Hello again, Your Honors. I do not have much more to say on this rebuttal, except for a few clarifying points on our position. And if the record on appeal is unclear, that is an oversight on my part, and I do apologize for that. So I want to clarify that the state primarily used the 1977 conviction, as the state said, which trial counsel at the time did object to, as there was an issue with the readability, for lack of a better word, of the paper and what the actual charge itself was. But the second conviction was this 1987 conviction for the conspiracy for possession of cocaine, which is, of course, where our issues lie. And that's what I want to focus on more in this rebuttal. As we saw with the 1977 conviction, trial counsel fleshed out an argument for why that should have been objected to, why that was not necessarily a proper conviction to use for the sentencing enhancement, and did not attempt any argument on the 1987 conviction. And as stated earlier, we feel like there was a very valid argument that could have been made for this conviction not being entered as a Class D felony, sufficient to range him up to a range 2 multiple offender.
So was trial counsel called as a witness at the post-conviction hearing?
He has actually
He's
passed
passed,
away.
that's right.
Yes, Your
Okay.
Honor.
Okay.
So unfortunately,
I
they
remember that, that's
relied
right.
heavily on the transcript itself.
So
Any-
if it's impossible to know then the reason for the failure to object to the 1987 conviction, but there had been an extensive objection to the earlier conviction from the 70s, how does that affect the post-conviction analysis? Like if there is no proof in the record about counsel's reasons for not objecting, how does that affect the post-conviction analysis?
It's a very good question. I'm not quite sure I'm understanding you. Could you reframe it for me?
Yeah, so sometimes, and I'm not suggesting this is a strategic decision or otherwise, but sometimes when the failure to object could be considered to be a strategic reason one way or another, and trial counsel will simply not ask the question, petitioner's got to prove the case by clear and convincing evidence and show both deficient performance and prejudice. And without the testimony of trial counsel in some cases, that may be very harmful to the petitioner's attempt to prove a meritorious case. Not saying that here because it's hard perhaps maybe to craft a strategic reason, but I'm just wondering about how the absence of trial counsel's thoughts during the sentencing hearing and the calls that were made by trial counsel, if we can never know that, how does that affect the petitioner's case here?
It's a very good question that I would need just a second to formulate a good response
No,
for.
you're fine, you're fine, yeah.
Don't mind. So just to clarify your question, are you asking how we intend to prove by clear and convincing evidence for this post-conviction relief matter that trial counsel was deficient in his performance and not merely making a strategic
So
advance?
in a lot of post-conviction cases, there will be a well-developed record with the petitioner testifying and with trial counsel testifying. Neither of those testimonies are before us in this record, as I understand. If we can't know, then the reasons that counsel didn't object, I was just curious on your view about how we should view that and how we should weigh it.
I feel like, as Mr. Moore did in the post-conviction hearing, we should rely on the transcript itself, which shows that Mr. Sharp had the ability to object and had the wherewithal to object to that 1977 conviction, and merely failed to object to the 1987 conviction and allowed the state to advance it as an enhancing factor for upping the sentencing range.
Okay, thank you.
Sorry if that wasn't
No,
clear and
that's-
concise.
No,
and-
you're fine. Thank you very much. Thank you.
If there are no other questions from your honors today, we ask, oh, sorry, thought you had a question. We ask that this court vacate the sentence and judgment that was previously entered, in that such judgment and conviction is void or voidable, and return Mr. Christian to pretrial status. Thank you, your honors.
Thank you. Thank you.
Madam Clerk, would you